So today we'll be providing a comprehensive session where we will be surveying a breadth of H-1B alternatives specifically for skilled talent. Our hope is that you'll walk away from this session really better understanding your options and hopefully walking away with a few creative ideas. So let's go ahead and jump right in here. A brief rundown of what we'll be discussing today. We'll be covering a myriad of visa options, ranging from those for early career professionals to advanced career professionals for global talent, both currently in the US and those abroad looking to relocate here. We'll start off by discussing early career pathways, focusing on students and recent graduates, particularly those in the US. We'll move into extraordinary talent, and then several options for mid and advanced career options or professionals, ranging from Ls, Es to early green card sponsorship. We'll then discuss 5 of the key J-1 visa categories available to talent at all career levels. And finally, we'll learn about a rather creative option for nearshoring remote tech talent in Canada. For those of you joining us, please do feel free to pop your questions in the chat. We will be addressing those at the end of the session. So before we proceed, I am joined today by a panel of highly experienced immigration professionals. So we'll go ahead and give a brief introduction of ourselves to you. I'll go ahead and kick us off here. I am Shaina Katz, Vice President and Responsible Officer here at AIFS Professional Pathways, with a longtime specialization in J-1 visas. AFS Professional Pathways is designated by the U.S. State Department to serve as a J-1 visa sponsor. So we're working closely with foreign nationals, U.S. businesses, and immigration firms in this certified capacity. Aaron?
Thanks, Shaina, and thanks, everyone. My name's Aaron Blumberg. I'm a partner at Fragomen. We're the largest and oldest immigration firm in the world. I've been practicing immigration law for 18 years, and nothing could prepare me for what we're experiencing right now. So it's a pleasure to be here with you all today, and I'll pass it on to Violeta.
Thank you. My name is Violeta Petrova. I am a partner in the immigration practice group at Gibney. I have been practicing business immigration for a little bit over 15 years. I work with clients, small, medium, large, and a lot of my current work is in the biotech space, also technology, financial services. Gibney is a New York-based law firm, and we are a full-service law firm. So in addition to immigration, we do employment, IP, corporate, and really our model is to provide turnkey solutions to companies entering the US market. Thank you. I'll pass it off to Arif.
Awesome. Perfect. Yeah. So hi, I'm Arif Khimani, the president and COO of MobSquad. As Shaina mentioned, we are a Canadian company that helps provide some innovative solutions where companies may be struggling with US visa related issues for some of their folks. And so we'll get into a lot more detail when we get to that section, but happy to be with you today.
Great. Great. Thank you. Thank you all very much. So a quick rundown of where we are today. So of course, the most significant changes that we have recently seen in business immigration, of course, relate to the H-1B. In September, we had the presidential proclamation, which imposed this new $100,000 fee for H-1B petitioners outside of the US, as well as changes to the existing lottery system, implementing this new tiered or weighted selection process based on salary and skill. And of course, these two things alone really are impacting the vast majority of H-1B applicants now this year. And of course, we're seeing that it's creating some talent barriers for folks as a result. This said, we are seeing that there is some promising little litigation taking place. But of course, the recent H-1B lottery has just closed. So anyways, to be seen what that impact and timeline of that impact may look like for us. Further, of course, we have seen the implementation of new social media vetting practices at the consulates for H-1B applicants and others. And then, of course, proclamations issued back in December and January, pausing immigrant visa processing for foreign nationals of 75 nations and non-immigrants from 39 countries. All of this to be said, of course, times are complicated. But what this does emphasize to all of us is the need for greater awareness of our available resources, the importance of compliance, of course, and really the need for proactive and creative problem solving, really considering options A, B, and C. So let's get into it.
Perfect. All right. So let's get started by talking about options for F1 students. So F1 is the visa for international students that are here in the US, and those students have opportunities to work. The first one being CPT, which stands for Curricular Practical Training. And this is work experience that an F1 student can have while they are in school. It cannot be done after they graduate. It's while they're in school. The training or work experience is supposed to be an integral part of their curriculum. And for CPT, we typically see this playing out in the form of an internship. Um, Basically, the university would have to authorize CPT. And by the way, every university authorizes CPT a little bit differently. The government gives schools discretion to decide how CPT is applied. And so some schools are very liberal and give CPT for most anything. Other schools only give it to certain programs or certain classes. So that's something that your potential student hiree would need to discuss with their school. And typically, CPT is only available after the student has completed 1 year of academic studies, unless they're a grad student and their program requires them to start immediately. So what do you as the employer need to know? First and most importantly, I think the best thing is it's free. There's no sponsorship. There's no fees you have to pay. Usually all you have to do is issue an offer letter, and then the student would bring that to their school, make sure that the opportunity aligns with their program, and then the school will issue a new I-20 with the CPT recommendation, and that's what you would use to complete your I-9. And just note, CPT is needed whether it is paid or unpaid. All right, so let's look now at OPT. So OPT stands for Optional Practical Training, and OPT can be done while someone is in school or after they graduate. And it's much more common to see that students save this for after they graduate. The rules on OPT are pretty basic. Basically, the student just has to ensure that they're working, paid or unpaid, at least 20 hours a week in a job that is related to their major. So pretty straightforward as far as the students go. You get 1 year of OPT after you graduate, and then if you go back to school and get a higher degree, you get another 1 year of OPT. So what does an employer need to know about OPT? Well, like CPT, what's great about it is it's free for you. You don't have to pay anything. You don't have to sponsor. The student applies on their own. They file a form. They pay a fee. You have to wait for their work permit to be issued. So with CPT, the student goes to their school, gets a form updated, and literally it could be the next day, they're ready to start. With OPT, the student has to wait a few months to get their work authorization. Sometimes students will apply for jobs while that's pending. Others will wait until it's issued. Once it is issued, the student can only be unemployed for up to 90 of those 365 days. And again, you can pay them or it can be unpaid. Whether you pay them or not, that more aligns with labor laws and not immigration law when it comes to OPT. And it's a really great way to test out an international student. And if they work out well, then potentially you can look to sponsor them in the future. Now, many students are going to be graduates of STEM programs. And so for students who majored in certain STEM fields, not all, but most, they may be eligible for a 24-month OPT extension. So 12 months of regular OPT plus 24 months of STEM OPT. Now, STEM OPT is quite different from OPT in the sense that the employer does have some more obligations and requirements when it comes to STEM OPT. First, the employer must be registered in E-Verify. So that's number one. Number two, the employer must work with the student to complete something called the Form I-983. There's no fee attached to it, but it is a detailed form where the employer and the student outline their training plan. Because remember, OPT, the T stands for training, and the government wants to see that the student is being trained. They want to see that they're being supervised, mentored, annual reviews are required. They want to make sure that the student's just not hired and then put off on their own, but that they're getting support, mentorship, and supervision. Additionally, for STEM OPT, you do have to pay the student, and they must be paid a wage that is commensurate with similarly situated US workers. So again, the 12-month initial OPT, you don't have to pay for them, and there's really not many requirements you need to be mindful of. But with the 24-month STEM extension, that's where your involvement has to go up a notch or two. But again, pretty low risk. You don't have to pay anything. You don't have to file or sponsor. And so again, all these options are great low risk ways to test out an international student and see if they're a right fit for your organization. All right, so let's turn the page. And by the way, actually, before we step to the next one, I will mention that we are expecting a regulation to come out later this year on OPT and CPT. We don't know what it's going to have, but we imagine that it will probably work to restrict or add additional requirements to OPT and STEM OPT. So that we'll just have to wait and see what comes out later this year. All right, so the O1 visa, this is for people of extraordinary ability. And this is not going to be a good category for most people. But there are some out there, and it's incredible how many extraordinary people we have in the US on certain visas. And so this is for really the creme de la creme. There's the O1A, which is for extraordinary ability in science, education, business, and athletics. And there's O1B, which is for extraordinary ability in the arts. Both take a very high level of national or international acclaim in order to be approved. And these are very subjective cases. One officer may think that your employee is extraordinary, and another officer may disagree. So we do see a good amount of inconsistency in adjudications. We've also seen over the last year that the adjudications are really tightening, and we're seeing a lot more denials and RFEs, which stands for requests for additional evidence. Now, if we look at the next slide, these are the actual requirements. So in order to get approved for an O1, you need to meet 3 of the requirements listed on the screen. On the left are the O1A requirements, and on the right are the O1B requirements. So when you file an O1, you basically have to provide evidence that they meet these requirements. And in addition, you have to show, generally speaking, that they're recognized nationally or internationally as being extraordinary in their field. So again, not an option for most people, but something to have in your back pocket in case you have that really extraordinary candidate who perhaps is not successful in obtaining an H-1B, or maybe doesn't qualify for a J or some other category. So it's something to consider. But I will turn it over to Violeta, who's going to talk about some of the other common alternatives to the H-1B.
Thank you, Aaron. Okay, so when we initially chatted about this panel, we sort of divided it into the 2 more or less broad buckets of early career pipelines and mid-career to senior talent. So Aaron covered the former with the F1 students. Extraordinary talent sort of traverses both. And my task is really to talk about more mid-career to senior talent. And I want to start with just a quick framing point. Because as Shaina alluded, the landscape has really changed significantly. So we have the two major changes for the H-1B program, which are the move toward weighted selection in the H-1B cap lottery and the introduction of a $100,000 fee for petitions on behalf of individuals who are outside of the United States. With these two developments, we are expecting a bit of rebalancing. And it really plays out differently for individuals who are already in the US, especially that mid-career to senior talent. This could actually improve their odds in the lottery. Higher salaries obviously tend to correlate with seniority, so they may have better selection odds, and the need to talk about alternatives maybe less. On the flip side, for companies that historically rely or have relied on the H-1B cap lottery to bring talent directly from outside of the US, the new fee is a real barrier. So in those cases, the need to think creatively about other pathways obviously gains greater importance. So what I'd like to do is sort of take a step back, walk us through some of the key options, and keeping in mind that the right strategy will really depend both on the employer structure and the profile of the individual. So let me get us started with the L1 intracompany transferee visa. So this is a really strong option for companies that have operations both in the US and abroad. The basic idea is that you're transferring an employee from a related entity overseas. So there has to be a qualifying relationship, like a parent, subsidiary, affiliate, or branch. The employee must have worked for that foreign entity for at least 1 year in the past 3 years, and they need to be coming to the US in either a managerial role or a role requiring specialized knowledge. Now, how does this work as an H-1B alternative? One common strategy is what we may call an L1 bridge. So if someone is in the US but does not get selected in the H-1B lottery, the company may consider transferring them abroad for at least 1 year and then bringing them back in L1 status, assuming that their position and background aligns with the criteria. We also sometimes see this work for individuals who are already in the US in another status, let's say somebody who's in F1 status who previously worked for a related entity abroad. So if that prior employment fits within the 3-year window, they may still qualify. So this is rare, but I've sometimes seen it happen. In terms of timing, L1B specialized knowledge employees get up to 5 years of stay, and L1A managers up to 7 years. From a process standpoint, you typically file a petition with the US Citizenship and Immigration Services, and then after approval of that petition, the individual applies for a visa at a US consulate abroad. But for larger companies who meet certain criteria, there is something called the blanket L, which can streamline things significantly by allowing direct consular processing. So in other words, the petition is presented directly at the consular interview when the employee applies for a visa. So that is really an excellent option for companies that qualify. A couple of key advantages of the L1 visa. It is a dual intent visa, so it does align well with green card sponsorship, and spouses in L2 status are work authorized. Let me shift next to treaty-based visas, specifically the E1 and E2 categories. So these are nationality-based visas, and they're tied to treaties that the US has with some 80 countries. They're called treaties of friendship, navigation, and commerce. Some of them have been in existence for a very long time. And the E1 is for treaty traders, so companies that are engaged in substantial trade between the US and the treaty country. The E2 is for treaty investors, where there is a substantial investment in a US business. For mid-career talent, the most interesting use cases are often around entrepreneurs, and the second one, companies that have the right ownership structure. So to take the first use case, let's say we have a founder from a treaty country who has the treaty country nationality, let's say has been in the US perhaps in F1 with STEM OPT or OPT, employment authorization, and maxing out. That individual might be able to transition to E2 status if they have made or about to make a qualifying investment in their business. On the company side, if the business itself qualifies, meaning it is at least 50% owned by nationals of the treaty country, the business can sponsor employees of that same nationality in executive, supervisory, or essential roles. And what is essential may be somewhat broader than people may expect. It includes specialized skill employees and employees who may be critical to launching operations in the US or scaling operations, particularly because of their familiarity with the company's systems or processes. One practical point here is that adjudication is very consulate specific, and it really tends to vary widely from one post to another. Some consulates have e-visa registration programs that make repeat filings much more efficient once the company secures that initial e-registration and is established in the system. Like most treaty visas, these can be renewed indefinitely, but they do require non-immigrant intent, so green card planning needs to be handled really carefully. So this brings me to another treaty-based option, and that is the TN visa under the United States-Mexico-Canada Agreement. This applies to citizens of Canada and Mexico and allows them to work in certain designated professional occupations. If the role fits within the list of eligible occupations, the TN can be a very fast and efficient option. Most roles requires at least a bachelor's degree, although there are some exceptions. One of the challenges, especially for tech talent, is that the occupation list hasn't really kept up with current professions. So for instance, there is no explicit category for software developers. Those roles often have to be mapped to engineer, right? Software engineer or computer systems analyst, but sometimes there can be challenges, particularly if an individual may not have an engineering degree to be mapped under engineer for software engineers. There is a scheduled review of this treaty that's upcoming in July of 2026, and there has been quite a bit of advocacy around modernizing the occupation list, particularly for areas like software development, AI, cybersecurity, and so forth. From a process standpoint, the TN is relatively streamlined. Canadians can apply directly at the border or at the airport, while Mexican nationals go through a US consulate, and individuals who are already in the US can apply for change of status. The TN is granted in 3-year increments, can be renewed indefinitely, again, with the caveat around non-immigrant intent. And 2 other nationality-based options I'll briefly mention are the E3 for Australians and the H-1B one for nationals of Chile and Singapore. These are very similar to the H-1B in terms of the legal standard. So the legal standard is specialty occupation, which means that the position must require at a minimum a bachelor's degree or equivalent in a related specialty field. And importantly, they also require a labor condition application to be filed with the US Department of Labor. And I'll just spend a moment here because from an employer perspective, this is often the part that feels most H-1B like. So even though E3 and H-1B1 are generally more accessible, employers have to make key wage attestations to the Department of Labor. So that means committing to pay at least the prevailing wage for the specific area of employment, and second, confirming that the foreign national is being paid on par with similarly situated employees within the organization. So they do carry compliance obligations on the back end, and that's something that employers need to be prepared for. The good news is that unlike the H-1B, the annual cap for both of these categories are almost never reached. So they function in practice as very reliable alternatives. Both can be renewed indefinitely, also like the other treaty-based options, subject to non-immigrant intent. And let me close with a few practical scenarios that we frequently see for mid to senior level talent already in the US. So first, as Aaron mentioned earlier, we have the O1 visa for individuals of extraordinary ability. And I think this category can be a very strong option for certain profiles, such as senior leaders, executives, employees in a critical capacity. The adjudications have indeed become more challenging with issuance of more requests for evidence, but they are relatively still stable. And I think for the right profile, this can be a really good option. And then second, we sometimes have individuals who are already in the US and L1B status, but need more time. And there may be an opportunity to transition to L1A status if their role has evolved in a managerial capacity. So that can extend their total stay from 5 to 7 years. And importantly here, managerial doesn't always mean having direct reports, right? So that is the traditional people manager. It can also include managing a key function within the organization. And finally, in some cases, it may make sense to consider early green card sponsorship earlier in the process. So in terms of the green card pathways, the PERM process, which requires testing the labor market, is still the most common pathway. It can take a couple of years because of very long processing times with the Department of Labor. But there are several pathways that bypass the test of the labor market, and those include the EB1, Extraordinary Ability Petition category, EB1 Outstanding Researcher category, EB1 Multinational Manager category, and EB2 National Interest Waiver category. All of these really need to be evaluated. They only make sense for certain profiles, but recently there has been forward movement in terms of the immigrant visa backlogs, so that may create filing opportunities in certain circumstances. That said, adjudication trends in some of these categories have been more stringent, so careful case selection is important. And I will leave it there and off to Arif. Oh, to Shaina.
That's fine. Great. Thank you so much. I will go ahead now and talk a little bit about the J1 visa category. And now this visa, of course, we're sort of capturing both early professionals up through mid and advanced level professionals. I'm going to focus on 5 specific categories, which are intended for that skilled talent. So I often tell businesses, if you are working with H's, L's, O's, of course, you have training opportunities like OPT or CPT. The J is absolutely worth incorporating into your strategy. So I always say that the J1 is probably one of the least understood, most underutilized visas for skilled talent. We often associate it with sort of those young seasonal hospitality staff members or au pairs, students. In addition to that, which is very important to the core of the visa program, it is a non-immigrant cultural exchange visa with underlying public diplomacy objectives. Further, it's housed under the Department of State. So given all of these things, there's often quite a bit of confusion around the visa category. The reality is, under the J1 umbrella, there are 15 different J1 visa categories, several of which are designed for those highly skilled individuals. And ultimately, they provide those foreign nationals with full-time work authorization that ranges anywhere from 1 week up to 5 years in duration. And it should be clear that each of these categories really have very distinct purposes, requirements, and the possibilities are quite different within them as well. In addition to providing full-time work authorization, a few other benefits of the visa program is that one, they can be used depending on the category for most industries. There is no filing cap, there's no application deadlines. In fact, with the J1, you are not filing directly with the government at all. Furthermore, just to add, the J1 holder can be accompanied by dependents on the J2 visa for the duration of their program, and those folks can qualify for work authorization after arrival as well. So one of the unique aspects of the J1 program, as I just noted, you are not filing directly with the government for this visa classification. What makes it a bit unique is that companies or employers generally act as or companies rather act as the legal employer. Usually they cannot also act as a visa sponsor. Instead, there are specific organizations designated by the US State Department to serve in this capacity. So in partnering with the sponsor, the foreign national and the employer will ultimately submit a series of basic information by way of what's generally considered a sponsorship application to this third-party sponsor. It is then at the discretion of the sponsor to evaluate both parties and the potential position for visa eligibility. And then ultimately, once deemed eligible, the sponsor will issue one or two federal documents which confirm ultimately the visa sponsorship and then allow the foreign national to apply for their visa at the US consulate. One quick note here, Canadians are exempt from this visa application process at the consulate. So once the sponsor issues their federal forms, the Canadian can then immediately travel into the US. You should expect that visa evaluation and extension of sponsorship process depends on the category and the sponsor with whom you're working with. That process usually takes anywhere from 1 to, I would say, 6 weeks. So just considering that in the planning process, of course, then accounting for the time at the US consulate. So that it is clear, a sponsor's job does not end once those documents are issued. They are also responsible for providing ongoing compliance and advisement, emergency and general support to both the J1 holder and the host company or employer. And the sponsor also bears the burden, if you will, of maintaining the foreign nationals' federal records, updating their federal documents, and any necessary federal reporting. So let's jump into a few of the categories here quickly. So first, let's talk about interns and trainees. These are often coupled together because when we look at federal regulation, first of all, sponsors generally, an intern sponsor generally also sponsors trainees, and the regulations are quite similar amongst the two. So first, interns, of course. This is as probably the most straightforward. These, of course, are individuals who are full-time students outside of the US in post-secondary programs or who have graduated from said institutions within the last 12 months. So this could also be a very early professional would qualify under this category. There's a minimum age limit of 18 years old, but no age maximum. So we're talking about folks who are enrolled in undergraduate degrees, graduate, PhDs, again, at any stage of their career in that respect. The intern positions rather, can range from 3 weeks up to 12 months in duration. Now, trainees, on the other hand, I often tell folks, don't be too misled by the title of trainee, although we'll talk about that in just a moment. Essentially, folks who are anywhere from green in their professional experience up through the C-suite can qualify for the JA trainee visa. These are folks who hold a post-secondary degree from an institution abroad and have over 12 months of full-time relevant work experience abroad. Or if they don't have that degree, perhaps they have a degree from a US institution, then they must have at least 5 years of full-time relevant work experience outside of the US. These folks, like interns, must be fluent in English. Again, there's no age maximum here, or there's no maximum amount of professional experience either. These trainee positions can last up to 18 months in duration. Now, from a regulatory perspective, the intern and trainee categories probably have the most requirements when it comes to understanding position and employer eligibility. So I'll quickly run through those. First of all, an employer can host a J1 in these categories. Essentially, you're an established business. You are registered, you have proof of prior experience, active, again, business activity. You are a responsible employer following all state labor and wage laws. Furthermore, the position that you are offering is full-time. It is related to the individual's prior experience, academic and professional experience. You're able to provide in-person business activity. So programs either have to be fully on-site at the business location, or they can be hybrid with 60% of the activities at minimum on-site. Again, this is a cultural exchange visa, so we need to ensure that there is that immersion and exchange in the US workplace. Now, what's important to note here is that, again, these are full-time positions. The intention is not for these individuals to come and observe business activity. They should be fully engaged. They are lending their expertise to business activity. They are collaborating on projects. They're collaborating with fellow American employees. We can generally categorize a position under the intern trainee category so long as we can justify that the foreign national has something to learn in this role. So are they learning specific methodologies or technologies that are, again, specific to the US or to the business entity here in the United States? How are they advancing their pre-existing skills? So that's really what we're most concerned about. These foreign nationals also have to have qualified supervisors based here in the US. There are, in terms of wage requirements, there's no specific dollar amount, but these foreign nationals are expected to be paid comparable wages to Americans in these roles. Furthermore, what makes these two intern trainee categories unique, there is one additional federal form. It's called the DS-7002, similar to what Aaron was discussing with OPT and CPT. This is called an official training plan. Essentially, it's a glorified job description that the sponsor will help to generate, and all parties will sign and abide by. Again, intern and trainee are great categories in the respect that virtually all industries can qualify for this role, all fields. The main areas to be aware of, however, prohibited, the two key prohibited areas are the fields of aviation and any field with patient care or contact. That would include elder care, child care, etc. So for example, if we're talking about medical, in the medical field, there could not be that patient interaction, but these individuals could be in a field of research. So we see folks here, again, anywhere from scientific research, a lot of folks using this in tech, business, architecture, law, etc. All right, and now the research scholar and specialist categories, again, sort of classified together here, mainly because these are individuals who can demonstrate expertise in their field, specialized skill sets that are of value to the U.S. organization where they will be pursuing an opportunity. So for the research scholar, we're seeing a lot more interest in this in recent years, particularly in the tech industry. These are folks, professionals, again, experts who are lending their expertise, researching, observing, consulting on projects. These are folks at employers who are American research or academic institutions. And again, right now we're seeing this popularity in corporate research facilities. So we see a lot of use of this visa now in R&D, for example, in tech and engineering firms. What's great about this category, folks can be here continuously for up to 5 years. Now, if you want to bring talent into this type of role for a shorter period, for a very short, say, consultative position, perhaps 6 months, we would just classify them under the short-term scholar category. What's also great about this specific area is that J1 research scholars can actually consult or even transfer to other employers during their program to lend their expertise. That just requires sponsor approval. Furthermore, F1 holders, there is an opportunity here for them to transfer into the research program. Specialists, quite similarly, These are the folks with specialized skills. This tends to lean a little bit more towards the observation and consultation side of the house. And really, the underlying goal of this program is to help build linkages between US and foreign institutions, corporations, etc. What's great about both of these categories also, there's quite a bit of flexibility with pay and stipends, as well as hours. So like we were saying with intern trainee, there's a 32-hour a week minimum that is full time. Here, while that is certainly the advice for research scholar, there is flexibility in both scenarios. And then very quickly here, the teacher category, this visa category is intended for full-time certified teachers abroad to come and manage a classroom in a K through 12 accredited academic institution here in the US. And those folks can come to both private and public institutions. And these programs can be, or positions can be approved up to 3 academic years at the onset, with the option to extend for up to 5. So the J1 is a great option for education as well. We see teaching assistants come in through the intern trainee program, and these full-time teachers come in for this cultural exchange opportunity under the teacher category here. And so with that, I will go ahead and pass it over to Arif.
Thank you. Lots of great options, as you can see, across the US. We're here to present a little bit of a innovative and unique option that may apply in some cases where none of the US options work for a particular applicant or company just based on their status or whatever the cause might be. And that's really an option to consider what might be available in Canada. And so if we look at what Canada can offer, relative to having people in the US, it can be a pretty seamless experience to have folks there. And what we're really talking about is the ability for a company to effectively nearshore in Canada through us, which is MobSquad, where we would hire the individuals as employees of ours, sign a contract with the company in the US as our client, so then you could then receive services from the person from Canada. And why we think Canada has some advantages relative to some of the other options like offshoring or going without an individual. It's a pretty similar legal structure and IP compliance structure to the US. So if you have talented technology workers that are conducting work in Canada, the IP protection back to US clients is basically the same as what you would have in the US. And so you can trust that your code base and other pieces are protected by that. There's also, the obvious ones where there's very good time zone and business culture congruency in Canada relative to the US. So, if you have a team in San Francisco or Seattle, you could look at Vancouver or Calgary as options, or if you have a team, in New York or Boston or kind of on the East Coast, you could look at Toronto and Halifax as potential options for locating folks. One that's really important is there are expedited immigration pathways in Canada, which I'll get into on a later slide, but there are ways to effectively get people into Canada from anywhere in the world within about 6 to 8 weeks. And it's a program that's available year round. So it can really help bring people into the country quickly. And then there are pathways that you can have people achieve their Canadian permanent residency, which is like the equivalent to a US green card, quite quickly as well. So it can be both a very quick solution for those that are needing something right away, but also a long-term answer for folks. And so, yeah, a little bit about how this would work from the Mob Squad side. We are a Canada-based company. We have offices in Vancouver, Calgary, Toronto, and Halifax. And our goal really is just to make it easy for you to access the world's best technology professionals from Canada. This solution works for both those that are abroad. So if you have team members that are in India or in Ukraine or in Brazil or anywhere in the world that you were hoping to bring into the US and they either didn't win the H-1B lottery or they were not entered because of the $100,000 fee that companies are worried about. Or if you have folks in the US that have expiring visas, so they might have had that OPT or STEM OPT that Aaron talked about, or another visa that's expiring, and they weren't able to either extend that or renew that or get an H-1B visa through the lottery system. we can move those folks to Canada. So we basically hire those individuals as our employees. So they go under our Canadian entity employment, which allows us to do the immigration relocation work, but then we also do payroll, taxes, benefits, office space, community and professional development. So they're fully taken care of in Canada. And then we sign a contract, as I said, with the US company so that you can continue to receive services from that person exclusively and on a long-term basis. So we're trying to create a win-win scenario here where people can either stay in North America instead of having to leave, or for those that wanted to come, they now have a pathway. While they might not be able to get into the US, they can at least come into Canada. For the company, you can continue to access these folks in a very, similar manner in the sense that they're in the same time zone and the business culture is the same. And, for us, we're just trying to help facilitate that piece of it. So I talked a little bit about this. I think it's helpful to just understand a little bit about how the immigration system works in Canada, and how it may differ from some of the systems in the US. So, specifically for technology workers, there's a work permit available through what's called the Global Talent Stream. It's available for eligible employees as well as eligible companies, of which we are one, but there are also others, of course, in Canada. And what this does is it expedites the work permit process for technology professionals from, anywhere from 3 to 6 months down to 6 weeks. So it's a very quick process. It runs year round, so it's not done on like an annual basis similar to the H-1B. You can actually apply for this at any time during the year. And it provides an open work permit for spouses and study permits for dependents so that the whole family can arrive on the expedited timeline. A spouse is able to work in the country and dependent children are able to go to school as needed. From there, there's permanent residency streams in Canada that help people basically obtain their permanent residency typically within 18 to 24 months. That can vary. It can actually be quicker, or it can take a little bit longer, but that's generally the range that we've been seeing. The programs available here that I'll mention is one is called Express Entry. Um, and this differs quite a bit from the US green card system in that it's a points-based system. So candidates get allocated scores based on their age, their work experience, both in Canada and outside of Canada, their language ability in English, French, or both, and their education, so any higher education that they've achieved. And there's additional point categories you can get if you have like a sibling in Canada or other things. But effectively, what happens is every couple of weeks, the government of Canada does a draw, and those with the highest scores based on that point-based system get invited to apply for permanent residency. And then on top of that, the provinces in Canada, so similar to US states, have the ability to nominate people that they believe would add value to their specific province. So this differs a little bit from the US as well, where it's all a federal kind of green card system. But in Canada, the provinces are able to nominate people for permanent residency, which allows them to select candidates that they feel would best match above what the federal system would do. And then from that, you can actually get your citizenship in Canada, typically within about 4 years, sometimes five, depending on how long you spent in the country, but it's a relatively quick and smooth process for that. My last slide here is just on eligibility for this program. So if you're a company that's, on this webinar or listening to this, effectively, if you're in any of the scenarios outlined here, so if you're at risk of losing tech professionals because of work visa issues, so people with expiring US visas, people who lost the H-1B lottery, people that a company may not be willing to sponsor for an H-1B visa for any reasons, including the fact that it may cost them $100,000 to bring them over. Or if you're a US company and you've got offshore tech teams and you want to relocate them to North America, but the US immigration process is too challenging and none of the pathways that were outlined, apply to those specific folks. Those are essentially the companies that we're able to support. So if you're in that situation, that's where, we'd encourage you to reach out. We can certainly share more, details on your specific cases. For employees, so the people that we hire and are able to kind of work with. Importantly, most of this is for technology professionals. So I've listed a few occupations on this slide. There are more of them, but generally, if they're a tech worker, we're able to help them with this program. And there are some other engineering graduates that we're able to help. So electrical engineers, aerospace engineers, and civil engineers also would apply for this program. They can already be in the US, so if they're in the US with an expiring visa, that works, or they can be abroad. If they're already working with a US company, either from the US or abroad, that helps the process for us a lot. So if you're in that situation, that's where we're generally able to help the quickest and best. And also one thing that's important is not having a criminal record. Canada is very strict on that, especially when it comes to DUIs. So if you've got a clean criminal record, then though and the eligibility criteria here, then you would generally qualify for the things that I was talking about.
Wonderful. Thank you all so much. Aaron, Violeta, Arif, I appreciate all this incredibly helpful information.